Next is sources of law. Okay. Now we know laws. What is law? It's some rules and regulations that we need to follow. Now it will from where these rules or regulations are coming, right? We will not simply have those rules and regulations. It will come from somewhere, right? So from where is it coming? That is called a source of law. All right. So source means the origin. Source means the origin from where law is derived, from where we are getting this law. If we are saying that any law that you know, you are aware of, what are the different laws that are there in India? There is something called as Income Tax Act, Indian Penal Code, right? What is that? That's a law. Now, if there is a law called as Indian Penal Code, it's not like one day from somewhere it just came and landed on Earth or India. It's not like that, right? From somewhere it should have originated. From where we are getting it, that's called a source of law. Okay, from where? Like we say, right? What is your source of income? Source of income as in from where you are getting money. Similarly, source of law means from where you are getting the law, right? So we need to understand from where we are getting those laws. So source means the origin from where law is derived. There are various claims and counterclaims regarding sources of law. That means for me, I may say that law originates from parliament. Parliament will pass a bill, it will become law, it becomes applicable. For you, you may say that no, it's not just parliament, but it's from our previous generation also we derive. Maybe what we are following from custom we derive, right? That means different people may have different opinions with regard to the sources of law, right? So that is why we are saying that there are various claims and counterclaims with regard to the source of law. For me, I may say this is source. For you, you can say these are the sources, right? There is always claim and counterclaim with regard to it. It is true in almost all societies, law has derived from similar sources, but more or less sources are similar. All right, there are some common sources from where we basically derive the law. Now, there was one jurist known as Austin. Okay, if you can remember this. There was a jurist named Austin who considered sovereign as the source of law. That means whoever is the supreme authority in a country, that person only gives the law. If there is a king who is sovereign, supreme, king will say certain things. Whatever king says, that will be applicable. You need to follow it. All right, so whoever is supreme or sovereign, that person will give law. So Austin said that sovereign is the source of law. Okay. Similarly, there were other jurists, Savigny and Henry Maine. They were again two jurists. All right, they were having a same opinion and they said that custom as the most important source of law. They said, no, it's not sovereign, but it's custom. What we are following for generations and generations, we are taking help of that to get a law. So custom is a better source of law. Okay, as per Savigny and Henry Maine, custom is a better source of law. But as per Austin, it's only and only sovereign from where law originates. That means depending on the jurist, depending on the person, there can be different sources. But ultimately, there are some common sources which are applicable in almost all the countries. Okay. So this you can write in introduction. Okay. If you can remember this part, it will give strength to your question also, answer also. You can write that. Now, classification of sources. There is another jurist who is an English jurist named Salmond. Okay, according to him, he classified law into these two groups, formal sources and material sources. Okay, for Austin, it was only sovereign. For Savigny and Henry Maine, it was only custom. And for Salmond, there are two sources, formal and material. Right, formal and material sources. What is formal source? These are sources from which law derives its source or validity. Take for example, law enacted by state or sovereign falls under this category. if India Parliament passes a law, that means it will have a force or validity, right? It is passed from Parliament. In that case, it will become a formal source, that it is having some authority or some value. So that is a formal source of law. All right. So for Salmon, there are two sources, formal source and material source. What is formal source?
Formal source which derives force and validity.
Which will derive force and validity. So if Parliament passes a law, that will come under formal source. Like Income Tax Act, it will be a formal source that we have. Okay.
Okay.
Next is material source of law. So I can even write here example, Income Tax. Okay. Similarly, any other legislation you can name it. Next one is material sources of law. It refers to the material of law. In simple words, it is all about the matter from where laws are derived. Custom falls under this category. All right. If there is a custom that is followed for generation and generation, we are taking help from that, and that particular custom also plays a great role in introducing a law, right? So that custom is not having sanction or validity of any authority, but still we will consider that this custom is a material source of law, right? From there we are taking help. So for Salmon, there are two sources: formal, having validity or having force, that is Income Tax Act; material source, where we do not have sanction or authority, but still it plays a great role, like custom. Is this part clear?
Yes, ma'am.
So if we look around and examine, like if we look at the contemporary legal system, what we have in India, we see that there are many different sources from where we have derived, right? Like we have legislation. So these three are like the common sources of law, all right? Whatever law you are talking about, more or less, they are derived from these three sources only. Okay, so what are these three sources? Custom, judicial precedent, and legislation. Okay, three different sources which we have. Now, all of these three different sources become important for you. Why? I have seen questions being asked. Write a short note on custom as a source of law. Write a short note on judicial precedent as a source of law. Write a short note on legislation as a source of law, right? So you need to read enough under each of these three different types. What is custom? Custom. Custom basically means some practices. All right, just as a practice we are doing it. Okay, whatever we have seen our parents do, we are doing it. Whatever our parents saw our grandparents do, they are doing it. That means just like a custom we are doing it, but it's not written anywhere that you need to do it. All right, so there can be certain habits or certain practices that we are following just like a custom, but it's not written anywhere that you need to do it, but we are simply doing it because we have seen everyone around us do it. All right. So customs are some long established practices or unwritten rules which have acquired binding or obligatory character. That means they have become binding on us. Why? Because we have seen that for a very long time. In ancient times, custom was considered as one of the most important sources of law. Why? Because now we have so many different legislations. Any particular area, you name it, you will get a legislation. We have legislation with regard to like child marriage restriction, child labor, education of child. We have so many legislations. But in earlier times, we were not having so many legislations. Right? So in earlier times, what happened was custom was a very important source. Right? With the passage of time and advancement of modern civilization, importance of custom as a source of law has come down, And other sources like judicial precedent and legislation has gained more importance, but still customs play a great role. All right, even now customs, we can take help of customs. Custom is an important source of law. For example, there is something called as Saptapadi. What is Saptapadi? Basically, 7 steps that bride and groom will take in front of fire, like we see in Hindi movies doing, right? So
Yes, ma'am.
Saptapadi was initially done like a custom. All right, it was just a marriage ritual that was there, and people started following it. Now those people started following it so much that now it has become a law. Under Hindu Marriage Act 1955, they have said if under your marriage ceremonies you need to follow this Saptapadi, then it is compulsory. You need to take it only. You cannot skip it. Okay, for the marriage to be valid, you need to take it. That means what? It's a custom. Initially, people were just doing it as a ceremony, but now it has become binding on the parties, right? So that is a good example of custom becoming a source of law. Okay, if you can remember, you can put this also. If there is a question, you can put this, that this is an example where custom has played a very vital role as a source of law, important role. Next is judicial precedent as a source of law. Now, what is judicial precedent? So when you see judicial, judiciary, that means it has got something to do with courts. Okay? Judicial precedent means some decisions of court will be followed. Okay? Those will be followed like a binding thing. Okay? So judicial precedent as a source of law. That means any decision that court has given, those will be followed. Those from there we will derive some laws. They will act as a source of law. Okay, so judicial precedent as a source of law. In simple words, judicial precedent refers to previously decided judgments. Okay, previously decided as in if a judgment came today, tomorrow, day after tomorrow, or in the coming days, lower courts will have to follow that decision. Okay, if Supreme Court today says okay, this is the law, that means lower courts will have to follow that. Okay, so judicial precedent will be applicable only when decisions are given by superior courts. All right, it's not just any court, but it will be superior courts like High Court or Supreme Court. If Supreme Court gives a decision, it will be binding on all the courts in India. Throughout India, whatever courts are there, it will be binding. You need to obey that, whether you agree or you do not agree. In case High Court gives a decision, that decision will be binding on, no, High Court is coming under Supreme Court. Okay, so High Court's decision will be binding on any other lower court. Okay, basically we have like a hierarchy of courts. At top we have Supreme Court. Okay, Supreme Court is the topmost court in India. So whatever decision Supreme Court is giving, it will be binding on any courts in India. After Supreme Court, we have High Court. At the state level we have, right? We have 25 High Courts in India at state level. So High Courts will come under Supreme Court. So High Court's decision will not be binding on Supreme Court, but it will be binding on all the other lower courts in that particular state. Okay, all the other lower courts like Magistrate Court, Session Court, Municipal Court, other courts, they will have to abide by that. But if Karnataka High Court gives a decision, Punjab High Court is not bound by that decision. Okay, it's not binding on them, but they can take reference. Okay, fine, Karnataka High Court gave this kind of a decision. It was a good decision. Maybe we can take help from that. But it's not binding on them. If they want, they can refer to that decision. Yeah, it's not binding. They can apply that. Yeah, if they want, they can apply it. So judicial precedent basically means previously decided judgment of superior courts like High Court or Supreme Court will be binding on the lower courts, right? So that is what is judicial precedent. This binding character of previously decided cases is important considering hierarchy of court that is established in legal system. So we will always look at hierarchy of courts. Based on that only, we will apply precedents in India. All right, is this part clear?
Yes, ma'am.
Now we are saying, right, that a decision of court. So decision of court as in two parties are having some dispute. Take for example, you and me, we are having some disputes or some fights. What we will do is we both will go before the court to settle the matter. All right. Court will hear both of us. They will listen to both of us and everything. Finally, they will come to a conclusion. They will give a decision. Right. So what is that? That is called as judicial decision. All right. This is judicial decision that court will give. In that judicial decision, they can say, okay, fine. It's not good thing to fight like that. So maybe this person was wrong. So you pay this amount of fine. All right. Court may impose fine on one of us. Okay. And court may say that why is it happening that people are fighting? Maybe because there is lack of communication in between persons, right? So there can be two different things in this judicial decision. Okay, one thing where they are giving a reason with regard to the decision. We both were fighting and court punished me saying that you pay fine of 6,000 rupees. Why? Because that's a wrong. Okay, that means it's a reason why they have given the decision. They can say that you have violated this particular law by fighting with her, so you pay 6,000 rupees fine. Why I am supposed to pay the fine? Because there is a law with regard to that, right? So court will say under this particular law, you have violated the provision. Now you pay 6,000 rupees fine. That means they are justifying their decision. They are simply not saying you pay fine. Why I am supposed to pay fine? That also they are explaining, right? That means they are giving a reason with regard to the decision. Why am I supposed to pay 6,000 rupees? That is the reason of the decision, which is called as ratio decidendi. All right, ratio decidendi. That means give the reason. You just do not give the decision, but reason for that decision. All right, ratio means reason, decidendi means decision. Reason of the decision, why you are giving this decision. Okay, so in first part, court will ask me to pay 6,000 rupees fine, and court will also give the reason that you have violated this particular law, so you pay 6,000 rupees fine. That is called as ratio decidendi. And apart from saying that, court also said, why is it that people have started fighting so much? It's because of lack of communication. Maybe because of COVID, everyone is just stuck inside their house. There is lack of communication, and that's why people have started fighting. That is what? That's just an observation that the judge made, right? That is just an observation that maybe because of COVID, people are just stuck inside their house. There is lack of communication. They have started fighting. So that is just a normal observation that judge made, which is called as general observation of the judge or obiter dictum. All right. Obiter dictum means just some other observations that court made. All right. It also forms a part of this decision, but it is not as important as ratio decidendi. Ratio decidendi is very much important, which will justify the reason why you have given the decision. And obiter dictum is just some random things that court said. That because of COVID, maybe lack of communication, so they both are fighting. Right? So that becomes an obiter dictum. All right. So when we say precedent, right, it is always the ratio decidendi part that is binding. All right, you need to follow the ratio decidendi part. That means ratio decidendi is always binding, and it is what we say as precedent. You need to obey whatever reason was given by Supreme Court, whatever reason was given by High Court. What about obiter dictum? Obiter dictum is not binding on you, but you can refer to that. Okay, you can say, okay, fine. In this case, Supreme Court said because of COVID, there is lack of communication, so people have started fighting. Maybe we can bring a new law and say that people should have some online calls or something frequently, maybe once in a month or something, right? That means They can take help of obiter dictum to come to a new law, but it is not binding. If you feel okay, you can refer to it, but it's okay if you do not refer also. All right. That is just there by the side, but ratio decidendi is the main part where you are justifying your decision, where you are giving reasons for coming to that decision. Okay. Is this part clear? It's very important. I have seen questions. Any doubts you can
Yes,
ask.
ma'am. No, ma'am. I'll read it today, and if I have doubt, I'll ask you tomorrow.
Okay. All right. Fine then. So in a court's decision, there will be two different parts. One is reason or justification for giving that decision. Another one is just simple observations that court may make. Now there were specific questions with regard to like write a short note on ratio decidendi, write a short note on obiter dictum. All right. So you need to understand it properly. So judicial decisions can be divided into two different parts. One is ratio decidendi or reason of decision, why you have given the decision. Ratio decidendi refers to the binding part of the judgment. That means it is some part which is binding on the parties. Ratio decidendi literally means reason of the decision. It is considered as the general principles which is deduced by the court from the facts of the particular case. We both went to the court and we said we are fighting for the last 1 week. And court said there is this particular legislation, so they will read the legislation, apply it to the given situation. Right? From the entire legislation, they will take out one provision, apply it to our situation, and they will give a decision that under this particular provision, you pay 6,000 rupees fine. So that particular part becomes binding on us. I need to pay 6,000 rupees fine, and any other courts can also refer to that particular decision if at any time it comes before them. So it becomes generally binding on lower courts in future cases involving similar question of law. If today Supreme Court asks me to pay 6,000 rupees fine, there is another case tomorrow in some high courts, they can refer to this decision and they can say, in this case they gave, so we are also giving this much amount of compensation, right? In similar cases, they will refer to it and it will be binding. It's not like an option. Obiter dictum, which literally means said by the way. Now we say, right, okay, by the way, what's your name? Right? I may be having a discussion with you for half an hour and then I may suddenly ask you, okay, by the way, what's your name? By the way means your name is not that important in that conversation, but by the way, I just wanted to know your name. All right. So by the way means what? Whatever conversation we are having, your name is not important in that conversation, but I just wanted to know it, right? Similarly, here also, court will give a decision, properly justify and everything. Some observations of the judge are not important in that decision, but still they can say that in deciding this entire case, I have observed because of COVID, people are stuck inside the house. And so there are fights increasing in between people, right? That's an observation which court made. So that will be an obiter dictum said by the way. All right, it's not that important also. An obiter dictum refers to parts of the judicial decisions which are general observations of the judge and do not have binding authority. Judge made some observations, it's not having binding authority, but obiter of a higher judiciary is given due consideration by lower courts and has persuasive value. Persuasive value as in I can refer to that. All right. My decision may be slightly influenced because of that particular thing. All right. That means it's not binding on me, but I can still consider it. I can still refer to that. And somehow I may be influenced by that particular decision of the court. All right. Is this part clear?
Yes, ma'am.
Having considered various aspects of precedent, that is ratio and obiter, it is in short called as ratio and obiter of a decision also. All right, ratio decidendi obiter dictum. It is clear that system of precedent is based on hierarchy of courts. Therefore, it becomes very important for us to know hierarchy of courts. So when it's a decision given by Supreme Court, Supreme Court is established by Constitution of India. Okay, it is the apex court in India. So whatever decision is been given by Supreme Court, it will be followed by all the courts in India. Similarly, if High Court is giving a decision, it will be followed by all the subordinate courts within the jurisdiction of that particular High Court. All right. And for other High Courts, it will have persuasive value. That means if they want, they can refer to it. If not, that is also fine with regard to them. Okay. So that is about, yeah, precedent and judicial decision. What are the different parts we have, right? A ratio decidendi and obiter dictum that we have. Next is kinds of precedent. So we were reading precedent as a source, right? Under precedent, what is precedent? Decision of a court, right? Under precedent, we have obiter dictum and ratio decidendi, right? Now precedent is having different kinds of precedents may be there. That means different kinds of decisions, court's decision may be there. Okay, so there was a question where they asked, what are the different kinds of precedents? Okay, so this becomes again important for you to read this part. Kinds of precedent. So there are different kinds of precedent. First is original and declaratory. Okay, these are two similar types of precedents. What is original and declaratory? First of all, what is precedent? It means some decision of a higher court which will be followed, which will be binding on lower courts, right? So there are two types of precedent, original and declaratory. What is original? Original precedent is where judges create a new law, right? And same becomes binding. That means there is no existing law as such, but higher courts have declared a new law. For example, I have given example for all these different kinds of precedent also. Okay, for example, in India, we were not having a legislation or any scheme to protect witnesses. Who is a witness? Take for example, someone committed a wrong. I was present there. I saw that thing happening. I am an eyewitness. I will go before court and say that, yes, I saw this person killing this other one, right? Now it becomes very risky for my life, right? Because I'm going to court and saying the things, this person may come and kill me also. So there should be some protection that is given to me. But in India, we were not having any law or any scheme to give protection to witnesses, right? So Supreme Court in one of the cases in 2018 introduced something called as the Witness Protection Scheme. And they said that this is how you should protect witnesses. And until and unless we have a legislation, it will be binding in India. That means what? It's an original precedent, right? We were not having any rules with regard to that area or that matter, but Supreme Court introduced something for the first time. So that becomes original precedent. That means nothing was there with regard to it. Supreme Court introduced this new concept, right? That is original precedent. The name is only very much understood, right? Original as in it was not there previously, origin, right? So you can accordingly remember it. Next one is declaratory precedent. Declaratory as in declare something. All right, what is declare? It's already there, but just you declare it, right? That is what is declaratory precedent. Declaratory precedent is where a known or established law is applied to a particular fact of the case. That means law is already there, but just that Supreme Court need to declare it very clearly or properly. Okay. Like you said, right, we have right to life. Few minutes back you said right to life we have. Under what provision we have? We have it under Article 21 of Constitution. Okay, we have right to life and personal liberty. Okay, now right to life and personal liberty is a very narrow concept. What is included under life? What is personal liberty? So Supreme Court in various decisions have included different things. That right to privacy is also included under right to liberty. Right to travel abroad is also included under right to life and liberty. right to clean air, right to education, all of those things are also included under right to life and personal liberty. That means provision was already there, Article 21 was already there, but Supreme Court declared it, right? They expressly said that these things will also be included here. Okay, that is declaratory precedent. So now it will be binding on all the courts throughout India. Is it clear difference between original and declaratory?
Yes, ma'am.
So next one is
Yes.
authoritative and persuasive precedent. Okay, so these are the two different types. First one is original and declaratory. Both are related somehow. Second category is authoritative and persuasive. Now, what is authority? Authority as in you have power, right? Authoritative means it is having power, all right? And persuasive as in you can somehow convince a person in some way or something, all right? So what is authoritative? Authoritative precedent is that which must be followed by the judges whether they approve it or not, as it is decision given by Supreme Court. So we know Supreme Court is topmost court. Whatever Supreme Court says, we need to obey it. All the courts in India will have to obey it. So take for example, you are a judge in Karnataka High Court. Okay, you are a judge in Karnataka High Court and Supreme Court has passed a decision with regard to a matter. All right, that, okay, fine, we don't need license for lawyers to practice law, you don't need license. Now, you do not agree on that point. Okay, you feel that no, license should be there, they should pass this minimum exam and then they should start practicing. So even though you do not agree with whatever decision Supreme Court has given, you need to follow that, right? You need to obey that. That means it is having authority, right? It's authoritative precedent where judges across India will have to obey it, whether they accept it from their heart or not, right? You need to follow it. You don't have any other option. That is authoritative. For example, judges of High Court will have to follow any order given by Supreme Court, whether they approve it or they do not approve. All right. So this is authoritative. And another one is persuasive. Persuasive precedent. What is persuasive? It is not having authority as such, but it can somehow influence your decision. All right. So what is persuasive precedent? Persuasive precedents are those which the courts are not bound to follow, right? It's not bound that you need to follow it, but you can consider that while giving a decision. You may refer to that also. All right. Now take for example, you are a judge of Karnataka High Court. Whatever decision Supreme Court gives, you need to follow that. That is authoritative. But if Delhi High Court gives a decision, it is not binding on you, right? Because you are at the same level with Delhi High Court. If you are a judge of Karnataka High Court, another judge of Delhi High Court gives a decision, you both are at the same level, right? You do not need to follow it, but yes, you can refer to that thing, right? If you feel, okay, fine, maybe that decision was good, you can refer to that and accordingly you can give a decision. Okay. Yeah, so you can take simple example. If your friend says, okay, fine, read these 3 questions for exam. Maybe you may accept it, you may not accept it, right? You may accept your friend's opinion, may not accept. That means your friend is having persuasive value. But from your college, they gave some important questions. That is like an authority, right? You believed on that, you forwarded that document also to me, that you want to read these questions. Why? Because that is having authority, right? That's like a authoritative precedent. And if your friend says, okay, fine, take, these are the important questions, that will have persuasive value. Maybe you will read those questions in a better way, but not like you will depend on those questions only. Clear, right?
Yes, ma'am.
Authoritative and persuasive. Now see, there are 2 more things. Like authoritative is further divided into 2 different types. Okay. First one is absolute authoritative precedent and second one is conditional authoritative precedent. Okay, fine, it's authoritative, you need to follow it, But again, there are two different types. One is absolute authoritative precedent. Another one is conditional. What is conditional? There will be some conditions.
Yes,
if you are going for, there may be some sale going on in a mall, they will say terms and conditions apply. What is terms and conditions? This sale will be valid only till they have stock, right? This sale will not be applicable for new arrivals or something. So that is condition. So here also it is conditional authoritative precedent. That means, yes, fine, there is authority, it will be binding, but under certain conditions only. All right, it will not be like overall it is applicable or something. Under certain conditions it will be binding. And absolute authoritative precedent means it's absolutely binding. You don't have any other ways, you need to obey it. So I will give an example. Take for example, authoritative precedents are subdivided into this. Absolute authoritative precedent must be followed without question. All right, take for example, Supreme Court gives a decision, all the other courts in India will have to obey it. It is absolute authoritative precedent. They do not have any other ways to escape, right? They need to follow it only. But it may be conditional authoritative precedent. That means Supreme Court of India will be binding or not. Like if Supreme Court of India gives a decision, another judge of Supreme Court will have to follow it or not.
it's okay. We can follow or else no. If we not follow, also it's no problem.
Okay.
We
So
can take it.
It is conditional authoritative. That means, see, it's not always like one person, one judge will be giving a decision. Okay, there are different judges also. Sometimes decision may be given by one judge. Sometimes it may be given by two judges. That is called as division bench. Sometimes it may be given by 5 or more than 5 judges. It is called as constitutional bench. So we will see how many judges gave that decision. Okay, if 5 judges gave a decision, that decision will be binding on any other judge, like less than 5 judges. If they are deciding, right, it will be binding on them, right? That means it's conditional authoritative. If 5 judges of Supreme Court has given a decision, that will be binding on any case, in any case where judges are less than 5.
Yes,
is it clear what is conditional?
Yes, ma'am.
Okay, so in Supreme Court, what happens? It's not always one single judge who is giving decision. It may be groups of judges. So if one group was bigger, that decision will be binding on smaller groups. Okay, that is conditional. So you need to fulfill that condition only when it will be binding. All right, that is conditional precedence. So these are the different kinds of precedent that you can see in this table. Okay, this will make it easier for you to remember. Okay, so kinds of precedent. There are mainly 4 different kinds that we have. Original precedent, where they are declaring a new law. Declaratory precedent, where an existing law, they are declaring it one more time. Authoritative precedent, which is completely binding. Persuasive precedent, which you may follow, you may refer, it's not binding on you. So these are the 4 different types of precedents which we have. All right, and authoritative precedent is again subdivided into absolute authoritative precedent and conditional authoritative precedent. Okay, so this is the division or different kinds of precedents which we have. So in case there is a question on precedent, or like write a short note on precedent, you are writing a very big answer where you are also including kinds of precedent. You can even put a table like this and draw it. Okay, fine, kinds of precedent, and there are 4 different kinds, and authoritative is further subdivided into 2, right? It makes it very clear and more presentable also, right? You can simply
we have to explain everything, ma'am.
Say it depends on the mark of question. Okay, like if it's 6
The last precedent, only a short note on precedents means if we'll write this and we'll explain also, no problem, ma'am.
Yeah, if they are asking like 10 mark like write a note on precedent and it's for 10 marks and you have enough of time, then you can maybe write about it, right? Kinds of precedent, maybe you can just explain these four, maybe you can explain, and these two just you can mention the names if you do not have time, right? It will ultimately depend on how much time you have in the exam hall, right? Accordingly you need to plan and strategize what all you need to write, what all you can skip. Okay.
Okay, ma'am.
So is this part clear? Precedent as a source of law.
Yes, ma'am.
Clear, right?
Ma'am, functions of law means essential functions of legal process only, no, ma'am?
Yeah, same only. Law as in they are just specifying, okay, fine, this is law. Legal process as in whatever legal things you have. Under a certain law, you have a right to go to court, file a case and all of that. So it's same only. Legal process also.
Okay.
Next is legislation as a source of law. What is legislation?
To make laws.
To make laws. Now, how does a legislation look? I will show you yesterday, okay, how a legislation looks. Legislation is basically a piece of document where everything will be written. All right, it's a piece of document where the law will be properly written. You can simply read the document and you will understand what is the law. All right. So now legislation as a source of law. Now, with regard to different matters, there will be laws. Okay, like you are from Karnataka State Law University, right? Now, university is what? It's a what? It's an university, right? Body of people. That university is also established under a law. Okay, there will be a law under which your university is also established, and how university will function, who will have powers or functions to announce dates for exam, admission fees, this, that, everything will be written in that law. Okay, so that is law. Law means for any different area there can be multiple different laws. Okay, we have different laws like Indian Penal Code. With regard to environment, we have law. Labor laws, we have law. There are different types of laws. Okay, so if you want, I will just show you how a law looks. All right, 1 second. So take for example KSLU Act, Karnataka State Law University Act. Whatever you want to say, just put, say this is the act. Karnataka State Law University Act. See, there is a law regarding establishment of your university also. This is called as legislation, okay? And it can be for different matters. So this is how it will look. This is like content that you have in your books, right? Same. Chapter 1 preliminary, then university establishment and incorporation, objectives, why this university is being established, powers and functions of university, that they can conduct exams, give degrees, officers under universities like VC, right, registrar and all of that, who will be there, right? So every single thing that you need, right, it will be mentioned, right? Academic council will be there, right? Every single thing will be written there. So this is a law. It's called as legislation. Similarly, you can see IPC Bear Act. What is IPC? Indian Penal Code. It provides for a list of different crimes that may be committed in India. All right. So that also looks somewhat similar to your University Act. If you look at this legislation, right? It's a very big legislation, although it's like 511 sections are there. All right. So see, accordingly, it will be divided. Punishment, what kind of punishment may be provided? Different kinds of offenses against state, criminal conspiracy, right? Accordingly, this is a legislation which provides for the basic things, right? Everything will be written here. See,
Written in a
different,
document.
yeah, different crimes will be mentioned, punishment, all of it will be written. So that is a legislation. And there can be legislation on any different topic. We have thousands of legislation in India. Okay, so this is what a legislation is. Now, legislation as a source of law. So legislation is already a law, right? How can legislation become a source of law? Take for example, for your university, you already have a legislation, Karnataka State Law University Act. Now, how can that law be a source of another law?
It will bind on.
What may happen is, today, for example, you have this law, okay, Karnataka State Law University is applicable, working fine and everything. Now, because of COVID, what happened is everything is becoming online, okay? They cannot take offline classes or something, okay? Now, in their legislation, that provision was not there with regard to online classes. So now they may feel ki, okay, fine, we have a law, but this law is not satisfying the purpose, right? Why we need law? To provide rules and regulations that will regulate us, right? Now, law is only not providing anything about online classes. So that means this law is becoming ineffective, right? So what they will feel is that because they have already this legislation, they will realize that we have some things lacking in this legislation and we need a new legislation, or we want to bring some amendments or changes in this existing legislation, right? So that is how it brings a new law. That existing law will tell you what all shortcomings are there in it, and you can improve it and bring a new law. All right, that is how legislation becomes a source of law. It will help you understand what is lacking in your legislation and accordingly bring those changes. All right, so legislation as a source of law. In modern times, legislation is considered as the most important source of law. Why? Because as I told you, we have thousands of legislations in India relating to almost every aspect that you can think of, right? So we already have a law. If you want to make some changes, you will refer that legislation and insert the additions. That means legislation is acting as a source of bringing those new laws. Okay. So this term legislation is, you can remember this also, the term legislation is derived from a Latin word legis, which means law, and another Latin word lectum, which means to set or make. Therefore, legislation means making of law. That means we are framing law. We are writing it very clearly that this is what will be applicable and this is what will be punishment or consequences for violating the law. All right. Importance of legislation as a source of law can be measured from the act that it is backed by authority of sovereign. It is directly enacted and recognized by state. In India, it will be passed by parliament, or for state, there will be state legislature, right? If a law is applicable only in Karnataka, state legislature may pass that particular law. That means it is having some valid authority, right? Accordingly, it will be binding on people. The expression legislation has been used in various senses. It includes every method of lawmaking. In strict sense, it means law enacted by sovereign or any other person, institution, or institution authorized by him. Basically, legislation means a law given by someone who is having an authority. Okay, is this part clear? Sources of law?
Yes, ma'am.
Clear, right? So sources of law, if there is a question, right, what are the sources of law, right? You can give an introduction where you can say what is source, right? Then you can say classification of sources of law. You can mention regarding Salmond, Austin, Savigny, Henry, Maine, and all of that. You can mention about formal and material sources of law. And then you can say that in general, we have these three common sources of law, which are customs, judicial precedent, as well as legislation. Yeah. Custom is some habit or practices that we are following since forever, and it has become a law, like Saptabadi. Then judicial precedent as a source of law. It means judicial decision. Whatever is already decided, you follow that rather than arguing on that or something like that, right? Judicial decision will have two different parts: ratio decidendi and obiter dicta. Ratio decidendi means reason for the decision. Obiter dicta means some observations that the judge made while giving that particular decision. Kinds of precedent: original and declaratory, and authoritative and persuasive. Authoritative may be of again two different types: absolute and conditional authoritative precedent. Yeah. And kinds of precedent, this is the table. And then finally, legislation as a source of law. It also helps us understand what things are missing in the existing legislation, and accordingly we will bring those changes also. All right. So this part is clear, I guess, right?
Yes, ma'am.